Welcome to Law Sessions. I am Jennifer Housen. In this law session, which consists of 4 segments, we will consider performance and breach in the context of a contract. Now, of course, we will look at when a contract is performed, and certainly we will look at when a contract is breached as well. So without much further ado, let's consider how is a contract discharged? Well, the discharge of a contract relates to the circumstances in which the contract is brought to an end. So you will have heard me speak about treating yourself as being discharged from a contract. It simply means that you consider yourself no longer bound under the contract which has come to an end. So where a contract is discharged, each party is freed from their continuing obligations under it. Now, a contract may be discharged in one of the following ways. Now, you can discharge by agreement, you can discharge by performance, you can discharge by repudiator breach, or you can discharge by frustration. Frustration will be for another law session completely, but we will certainly look within this session on agreement, performance, and repudiator breach. Now, if we get rid of the easiest first, discharge by agreement. Well, contracts are made to be performed. That is the idea. And so once it is performed, then of course your obligations will have been completed under the contract. So if we consider discharge by agreement, a contract of course may be discharged where both parties agree to bring the contract to an end and therefore release each other from their contractual obligations. Now, for a contract to be discharged through agreement, there must be what is called accord and satisfaction. This is really a fancy way of looking at what we would have touched on in the first law session, which of course was offer and acceptance. Now, accord simply talks about an agreement in that each party must agree to end the contract. The agreement must be freely given, and equally there must be consideration for it, where both parties must also provide consideration. If both parties have continuing obligations, then generally the consideration will simply be each of them giving up their rights under the contract. Now, the only time consideration becomes an issue, of course, is where one party has fully performed their part of the contract and the other party has not. The non-performing party must then provide consideration to make the agreement binding. Equally, if the agreement is made by deed, there is no requirement to provide consideration, because at common law, the deed will be recognized and it is not necessary for there to be consideration. Now, there is in effect a contract to end a contract. So you've decided, I give up something, the contract comes to an end, and you have accord and satisfaction. You need go no further. The contract is discharged. Now then, discharge through performance. As I said, a contract is made to be performed, so a contract becomes discharged through performance where both parties have fully performed their contractual obligations. Now, performance must exactly match what was promised. Now, in entire agreements or in entire contracts, performance must be complete in order to discharge the contract. Meaning that if you have a contract that has, for example, several parts to it, but it considers itself an entire contract, it can't be that you say, well, I did the first part, just pay me for that. If it is that the entirety of the contract depends on it being performed before, for example, you get paid, in such a situation, then it must be that it is completed. The time for performance, well, in equity, time is not of the essence unless the contract makes it so. And the case for that, of course, is Lombard North Central and Butterworth 1987. Or reasonable notice is given to make it so. Cases Rickards and Oppenheim 1950. Or the content of the contract make it so. So the general rule is that just because I make a contract with you and it actually has a date in it does not mean time is of the essence in relation to contract. Indeed, even in land law contracts, time is not of the essence if it just simply has a date. But if it is expressly stated that time is of the essence, then arguably it will. But just saying we must complete by January 1st does not make it time of the essence. Now, at common law, it is similar to equity, and in Ranieri and Miles in 1981, it was held that the late performance will not normally entitle the other party to terminate, but he may, of course, sue for damages. Now, if one party does not fully perform the contract, this will amount to a breach of contract, and the other party may have a claim for damages unless the contract has been frustrated. Now, if the non-performance amounts to a repudiator breach, meaning that what you've breached is a condition as opposed to a warranty, the other party will be released from their obligation, so the other party can treat himself as discharged from the contract. Now, where a contract is one where the price is payable on completion, then completion is generally required in order to discharge the contract. Now, this is often expressed in the terms of being a condition precedent. Completion will trigger the requirement of payment. If there is no completion, there is no payment. Now, this general rule, of course, was established in the well-known case of Cotter and Powell, and is obviously capable of causing some real injustice. And this is a case from 1795. And what had happened was that the claimant's husband had agreed by contract to act as a second mate on a ship. The ship was the Governor Parry on a return voyage to Jamaica. Now, the voyage was to take 8 weeks, and he was to be paid on completion. The difficulty was, of course, that in the contract, there was a term that said 10 days after the ship, Governor Parry, myself, master arrives at Liverpool, I promise to pay to Mr. T. Cotter the sum of 30 guineas, provided he proceeds, continues, and does his duty as second mate in the said ship from hence to the port of Liverpool, Kingston, July 31st, 1793. Well, 6 weeks into the voyage, of course, he dies. Very inconsiderate of him there. But the claimant then sought to claim a sum to represent the 6 weeks' work undertaken. So this was his wife. So his wife is saying, all right, he's done 6 weeks' work, at least pay him for the 6 weeks' work. Well, the wife's action failed, unfortunately. The court said that the payment was on the condition that he worked the ship to Liverpool. Since he did not fulfill this condition, the widow was entitled to nothing. Now, the harshness of this rule, clearly it is a harsh rule, relating to discharge through performance, has been mitigated somewhat by the law creating various exceptions. Now, not least, the court said that if there is a divisible contract, sometimes called a severable contract, then that may operate to mitigate the harshness. Now, under a divisible contract, the rule relating to discharge through full performance applies where there exists an entire contract. Where it is, though, that it is possible to divide a contract into separate parts, example, if a sum is agreed to be payable per week or hour, then the courts can award a sum for the separate parts of the contract which have been completed. Now, we clearly see that this rule is an extremely harsh rule. The court and the later cases have come on board to mitigate that harshness, and certainly we see it moving along that continuum. What I'll do now, though, is take a short break, and immediately after the break, we will come back and continue with performance and breach.